Okay, hello, good afternoon. Thank you all for being here. We do hope everyone is well and staying safe. Today is Tuesday, August the 18th. We are Russo Law Group, Long Island's signature elder law, special needs, and estate planning law firm, and we are back for another live webinar. This presentation is New York State Estate Tax Planning. My name is Ashley, and I'll be introducing the firm's managing partner, who just so happens to be today's presenter, Vincent J. Russo. Vincent has been certified as an elder law attorney since 1995, and he's earned his Master's of Law in Taxation. He's a founding member, fellow, and fifth president of the National Academy of Elder Law Attorneys. He's co-founder of the Teresa Alessandra Russo Foundation for Children with Special Needs. Vincent authored the seminal treatise, New York Elder Law and Special Needs Practice for lawyers practicing in New York. He's also appeared on national televised shows such as NBC's Today Show, and he created and co-hosts the cable TV show Family Comes First. So before I pass it over, I have two housekeeping announcements. This is a live webinar, which means we are available to answer your questions. And yes, we do encourage your questions and participation. So please send your questions and comments in the Q&A box provided in the Zoom toolbar located at the bottom of your screen. If you're joining us through Facebook, feel free to drop your questions using the comments section. Also, let us know how we did by please completing the short survey that will open in your web browser once you exit Zoom. Okay, that's it. I will now hand the mic on over to Vincent.
All right, welcome everybody. I just want to do one thing here that make sure we don't have any sound coming up unnecessarily. Looks good. So today is the part 2 of our estate tax planning web series. On July 21st, I did the nuts and bolts of estate taxes, both federal and New York State. And so that's laid the groundwork. And I also talked about what happens if you do not have a taxable estate. What should you be looking at in terms of making sure you don't create any unnecessary income tax taxation, such as capital gains. Step up in basis is an important element of that. So for today, I'm going to talk about does the New York State estate tax apply to me? If it does, what can I do to avoid the costly New York State estate tax cliff? And what strategies are available to save New York estate taxes? So we have a lot to talk about, focusing in on New York today. The starting point would be to figure out what is the size of your overall estate that could potentially be subject to estate taxation. Basically, your estate consists of everything you own or have an interest in at the time of your demise. So the assets that would comprise an estate could be real estate, if you own a residential home, commercial property, rental property, bank accounts, cash, annuities, brokerage accounts, savings bonds, life insurance policies that you own and are the insured, for example, retirement accounts like 401k or IRAs, pensions, vehicles, jewelry, art, other collectibles, interests in a business, such as a subchapter S corporation or an LLC. Now, when you add all that up at fair market value, you then subtract any debts that you own. So if you have a mortgage, perhaps on real property, that would reduce the size of your estate. Once you have that value, we then need to look at the estate tax laws federally and in New York. So we start with the tax rates. The maximum tax rate, federal, is 40%, and New York State is 16%. So that's a significant amount of taxes if your estate is subject to estate taxation. The good news is there's an exemption. And that exemption at the federal level is $11,580,000 in 2020. That's a significant amount. So roughly 1% or less of the population in this country are subject to federal estate taxes. Now, we'll be talking in later workshops about how the federal estate tax laws work and how to avoid federal estate taxation. Today, it's going to be all about New York, and the New York exemption is $5,850,000. Also, a fairly significant amount. So if you have an estate under $5,850,000, there is no New York estate tax and no federal estate tax. And that doesn't mean, though, that you shouldn't do any tax planning. Go back to my nuts and bolts webinar, July 21st, for more details. Now, New York State also has a trap, and I'll be talking about this in more detail later, but I just want you to know about this amount. The amount for the New York State estate tax cliff is $6,142,500 in 2020. Stay tuned. Now, let me give you an example of what that tax might look like based on the size of your estate. Good news, if you're under $5,850,000, there's no federal and New York tax. Bad news is, I wish you had more assets. At $6,142,500, that's the tax cliff number. No federal tax again, but the New York tax is $528,240. That's $500,000. That is significant. We're going to talk about how to save that tax. If my estate was $11,580,000 this year, no federal estate tax, but look at that New York tax. The New York State estate tax is $1,319,600. Wow, that's a lot of state estate taxes. And then for those who have really done well and their estates are in the $23 million range or more, at $23,160,000, that New York tax jumps up to $3,172,400, plus another $3,363,040 of federal taxes. We get to a total of $6,535,440 on a $23 million estate. That last row will be the subject of my third and fourth webinars. We're going to focus in on the second and third row, where we start with an estate over $5,850,000 and basically under $11,580,000. So why should you do estate tax planning? Well, people in New York State with assets over $5 million should really be looking at doing estate tax planning. They're getting very close to crossing over where there would be potential New York State estate taxes. And if your estate is even much more significant, we run into federal taxes. The New York State estate tax law, as you see, is not as generous as the federal estate tax laws. And these laws can change from time to time. So we have to monitor this on an ongoing basis. If you reside outside of New York, then it will depend on which state you are domiciled in terms of that state, whether it has estate taxes or inheritance taxes. So how can I avoid New York estate taxes. So we have to talk about a couple general rules. The first is there's no New York State gift tax. So anyone can gift any amount of money out or assets out of their name, thereby reducing their estate for purposes of estate taxes without any payment to New York State for making the gifts. That's very generous. There is a catch. We'll talk about the catch a little later. As everybody is well aware, at the federal level, you can give away $15,000 per year per person. So that's a way of giving gifts without using up what's called the Unified Gift and Estate Tax Exemption. So that federal exemption of $11,580,000 is a combined exemption, taking into account any taxable gifts during your lifetime or the value of your estate at the time of your demise. So you can use all those $15,000 per person per year without any adverse impact on your exemption amount. And while you're alive or upon your demise, in combination of the two, you have a pot, so to speak, of $11,580,000 before there would be any gift or estate tax. So when we look at someone who has over the threshold where New York State now would look at taxing that person on an estate tax basis, you can reduce the size of your taxable estate by making gifts. You can make those gifts outright to individuals, to charities. You can make gifts to trusts, and as long as those trusts are set up in the proper way, those assets would no longer be part of your estate. Typically, that would mean placing it into an irrevocable trust. You can take your life insurance policies that you own and put it in an irrevocable life insurance trust. So here's a way of, by a gifting program, where you can reduce the size of your estate, get below the New York State exemption amount, and avoid New York State estate taxation. You want to be smart about the gifts. That's why we highly recommend you consider gifts to trusts. It's the most protective way of making gifts to family members or any individual you choose to give it to. So let me give you an example here of the gifting program. So if I had an estate of $11,580,000, there's no federal estate tax. I'm right at the threshold. New York's estate tax, as I mentioned earlier, $1,319,600. So if I was to make gifts of $5,730,000, that would reduce my estate to $5,850,000, and I would have converted a potential estate tax of $1,319,600 to zero. The tax savings is $1,319,600. How hard did you have to work to accumulate that wealth? Well, through a sound, well thought out gifting program, which we can help you with, you can save your family over $1 million. Now, little rub here, little condition. Those gifts have to be made more than 3 years prior to the time of your demise. So you cannot implement this planning strategy on your deathbed. You need to be doing this in advance. Now, I want to go and talk about the benefit here where we see a problem that I want to address. And we said the problem is that New York State, once you're over that $5,850,000, is a taxable estate. We just gave you the solution. A gifting program, which reduces your estate below the exemption amount. Preferably, now I want to add this, preferably the gifts being assets with little or no appreciation or assets that you have no intention of selling. Because if you make a gift of a highly appreciated asset and then it's later sold, it's going to create capital gains taxes. So we can avoid the capital gains taxes by gifting assets with little or no appreciation or gifting assets that we don't intend to sell. And by this strategy, you're achieving significant estate tax savings. Now I want to move to the trap. This is horrible. The New York State estate tax cliff. New York State has a provision in their estate tax laws that you will lose your exemption in its entirety if your taxable estate is in excess of 105% of your New York State estate tax exemption. So what does that mean? Well, in 2020, as I've mentioned, the exemption is $5,850,000. 105% is $6,142,500. If your estate is that amount, $6,142,500 or greater, you lose your exemption. So we're not taxing every dollar over $5,850,000 at 16%. We're taxing your entire estate from dollar one. And that's going to create an estate tax of $528,240, even though your estate is in excess of the exemption by less than $300,000. This is crazy. This does not make sense, but this is the law. This is a trap. And I'm going to talk to you now about how to solve this problem. The first step would be if you can get your estate under $5,850,000 through a gifting program. The second step would be to have a tax savings clause. This would be a provision you'd put in your will or your revocable living trust. And that provision, sometimes referred to as a Santa Claus provision, actually, provides that the amount by which your estate exceeds the exemption amount, that excess will pass to a designated charity, so long as the amount passing to the charity is less than the increase in New York State estate taxes. I'm going to say it again, and then I'm going to give you an example, because this is a complex thought as to how this law works. If you're over the cliff, then the provision would say, give the excess amount over the cliff to a charity. That would bring your estate down to the exemption level where there's no New York State estate tax. But we're only going to do that in an amount up to when we get to a point where I'm better off paying the tax and some money will pass to my family. If I'm in a situation that by paying the charity, I'm going to actually save estate taxes and give more to my family, then that's okay, and that's how the formula works. Let's look at an example. Okay, so let's say your estate is $6,342,500. So we're $200,000 over the cliff. New York State estate taxes would be $553,840. We don't want to pay that tax. We want to reduce it. So the tax savings clause would come into play, and we would give the charity basically $200,000. To be more exact, $200,001. So now you're helping your favorite charity, and that's a good thing. That would wipe out the New York estate tax. The savings then in estate taxes would be $353,839. By saving that estate tax money, that you were going to give to New York, you're now going to give it to your family. So now you've helped your family get more from your estate, and you've helped the charity at the same time. It's a win-win situation. So if you have an estate that is close to the exemption level or is over the exemption level by $1 million or so, you would want to make sure you have a tax savings clause in your will or trust. The last concept I want to talk about in relationship to New York estate taxes is planning for married couples. Now, you probably all know already that if you're married, you can leave your spouse an unlimited amount of assets without paying an estate tax on the first to die. That sounds great. I don't need Vincent or some, professional who's experienced in estate tax planning. Isn't that the easy solution? And the answer is no, because when that second spouse dies, now they even have a larger estate because they inherited assets from their spouse. And now that surviving spouse's estate is going to be subject to estate tax. So when we talk about the exemption amount, the New York exemption being $5,850,000, each person has that exemption. So as a married couple, you double that number. But what's important to understand is that it's an individual right of this exemption, which means that when the first spouse dies, if they don't use their exemption, it's not portable. It doesn't carry over the unused portion to the surviving spouse. Effectively, an unused New York State estate tax exemption is lost, and that's bad. So if someone had an estate of $10 million and $1 million was in the one spouse's name and the other 9 in the other spouse, and the one with the $1 million died first, they would only use $1 million exemption to offset the $1 million they have, no New York tax. But they didn't use the $4,850,000 remaining. So now, instead of each of them sharing the estate in a way that they both could use the exemption, the surviving spouse with the $9 million is now going to get hit with a very significant tax. So the solution here is for the married couple to implement an asset allocation where we want to separate the assets and not have them owned joint with right of survivorship. And we want to make sure that we've done this analysis very carefully, retitled assets so that each spouse would have assets under the allowable exemption amount that each of them has. Let's look at an example. Let's say the estate was $7,142,500. And if it passed without any planning to the surviving spouse, no problem, no estate tax. But when that second spouse dies with that amount, the tax would be $656,580. What could this spouse do? They could do a gifting program and get under $5,850,000, or they could divide the estate in a way that neither spouse has more than $5,850,000. And the way we do it as planners is to put provisions in your will or your revocable living trust. And that provision is referred to as a credit shelter trust, so that rather than assets passed directly to the surviving spouse, they go into a credit shelter trust. So they're taxed on the first spouse's estate, offset by the exemption, no tax. And those assets are not included in the surviving spouse's estate. And so they're not going to be taxed later. This would be a way of zeroing out the New York estate tax on the death of the second spouse. So if we split the assets, not joint with right of survivorship, so each spouse owns a share of those assets, and the spouses put a credit shelter trust provision in their will or revocable living trust, we will have effectively zeroed out the tax and saved the family $656,580. That's a significant savings on a roughly $7 million estate. The last point I want to make today would be about talking to you as to non-tax reasons for estate planning. That everyone wants to pass their assets on to family, loved ones, without any problems. And if you want to avoid problems, you want to have a comprehensive estate plan. You want your will or revocable living trust to be very clear about what your intentions are. And you want to pass those assets in a way that can be protective. Also, if you want to avoid probate, then you would want to have a revocable living trust to be able to do so. Now, when we avoid problems with the assets passing on to family, the next tier here is to think about, well, I not only want to do that, but I want to pass them on in a protective way. Perhaps I have a child with a disability or a special need, or a concern that they may spend those assets and money down very quickly, or not in a way that would really be in their best interest. So a couple different types of trusts that we typically would recommend. If you have a family member with special needs, we would suggest that you have a special needs trust for that family member. So the assets can be held for the benefit of that family member without adversely impacting their access to government benefits. And also you have a plan for proper management of those assets. In some situations, we're even asked to be the trustee, and we're happy to do that. Safe trusts, or what we also refer to as family protection trusts. I'm concerned I leave a couple $1 million to my son, but he's got marital issues. And what happens if there's a divorce? Or you may have a child with creditor problems, or tax issues, or they're just not good at managing assets. Or you're just concerned that maybe that could happen to any one of your good children. It won't be their fault. So how can you leave assets in the most protective way? Also, as we all age, we want to have plans in place to cover long-term care, either through insurance or by accessing government benefits. So there are a number of really good reasons, non-tax related, why you would want to do estate planning. So the strategies today were totally focused on New York State estate taxes. I know we got very technical and there were a lot of numbers involved, but we will publish this webinar on Facebook and our website so that you can go back and listen to it more carefully. And of course, attorneys in my firm are available to help you. Just give us a call. So there are strategies to save estate taxes. Gifting and the use of trusts are two excellent strategies. The key here is to make a commitment of your time, energy, and willingness to pay legal fees to implement a plan that's going to make sense for you. That's what's most important. You need to be comfortable with any estate tax plan you come up with. And rest assured that whatever the legal fees are to implement a plan and out-of-pocket disbursements, it will be nothing near the tax savings that will be generated by you being proactive and doing this planning. So what do you do now? If you don't have a plan, create one. If you have a plan, review it, update it, make it more comprehensive. think about retaining the services of our law firm. We are equipped to handle estate tax planning issues, estate planning when there are non-tax reasons to do it, elder law, special needs, representing veterans. We have decades of experience among the partners and associates of my firm. The key for you is to do something. Get your plan implemented. It's on you. The government is not the generous, focused entity out there that says, don't worry, when you die, we'll make sure you got use of, you took advantage of your exemption, and we'll make sure you pay the least in taxes. No, that's not going to happen. Every individual is in charge of their own estate and will determine how much that estate tax will be based on whether they do planning or don't do planning. With that, we'll check in with Ashley whether there are any questions.
No, Vincent, I don't see any questions just yet.
All right, so we'll give it a minute here and see if any questions come up. I know it was a very technical presentation, but I wanted to be accurate. I wanted to be very careful in what I said, and I wanted to give you some examples that you could refer back to, because I think seeing how much money potentially is at stake when you have worked so hard to accumulate an estate, to then have it taken from you by the government, and you're going to rely on them to use your estate for the benefit of society. If you love your family, then why not make sure your family gets the most, or your friends, or a charity that can do some real good. So let me talk to you for a minute or so about, I see, is there a question, Ashley, that just came up?
There is, yep.
All right, who's the question from?
Corrine.
Okay.
In New York State, is there a law which permits shares in a co-op to be included in a revocable trust?
Okay, so kind of two questions here, I think. I'm going to bifurcate it. So you have a co-op and you want to put it into a revocable trust. Well, first, New York law applies as to whether that can be done. New York law does allow for the transfer of a co-op, the ownership of a co-op, into a revocable living trust. But the second prong depends on the co-op board and their bylaws. So if the bylaws say it's okay, then it's okay. And if the bylaws say it's not okay, then you're not going to be able to transfer your assets, that co-op, into the revocable living trust. So you got to ask your co-op board. Now, if your co-op board says they will not allow it, we've been brought in on a number of situations where we were able to convince the co-op board to change their policy. And so don't give up right away. You might still be able to work it out.
Okay. We had another question from AJ. It says irrevocable versus revocable trust.
Okay. So basically, a revocable trust is one that you set up while you're alive, and you can change it anytime you want. You can change the language and the provisions in your trust. You can terminate the trust. You can take the assets out of the trust anytime you want. You're in total control. It's a great feeling, right, to be in total control. But New York says, good for you. You're in total control. So when you die, we're going to tax that trust. And if you're over the threshold, we're going to have a New York State estate tax. Thank you very much. Irrevocable is a trust you set up where you cannot directly change the provisions of the trust in the future. There are certain limitations on control, but now those assets are outside of your estate. So it can be drafted in a way so that those assets won't be in your estate, and New York State will not be able to tax you as long as you outlive the transfer by 3 years. Now, that makes a lot of people nervous. Vincent just said will be limited control. What does that really mean? Well, come talk to us, because by the time we're done, you're going to say, sounds like an irrevocable trust is just like a revocable trust. We can put provisions in the trust that allow you to make certain changes. We can do it in a way that someone else could change it for you. And so there are a lot of ways of giving you control without violating the New York and federal estate tax laws, where they'll bring that asset back into your estate. I think we generally will make over 90% of our clients comfortable with doing irrevocable trusts to save estate taxes.
Okay. Rodrigo, I may ask you to clarify this question, but Vincent, I'm going to ask it as I see it typed out. Rodrigo asked, if I split the assets with my wife and then I pass away and I will my assets to her, what does it happen when? And he just sent another one. If I split the assets with my wife and she is the beneficial of my will her estate be subject to tax?
Okay, so splitting your assets, as I said earlier, is a good idea when you're doing estate tax planning, general statement. But you're basically, in what you've explained to me, you've undone the good of splitting your assets, because you left your assets to your surviving spouse. Your surviving spouse will get those assets estate tax free if you die first. That's the good news from a tax standpoint. It's not good that you passed away. I want everybody to live a long, long, long time. But now your spouse has all the assets. And when she dies, those assets will be counted as part of her estate, subject to estate tax. So splitting the assets up, good idea. Leaving it directly back to the spouse, from a tax standpoint, bad idea. We need a credit shelter trust provision in your will or revocable living trust. Do we have another one?
Okay. Nope.
Okay. Well, thank you so much. Those were great questions. I'll just mention for a moment about what makes Russo Law Group different. I think our experience in these matters of estate planning, estate tax planning in particular. We've got 4 convenient office locations on Long Island and New York City. We're very experienced in handling complex matters, especially families who are in crisis. We work with attorneys all over the country. We're also licensed in a number of different states, including Florida. And we have special client offerings where clients can really benefit from being a client of the firm. We're proactive in having a client maintenance program, and we give discounts on legal planning for family members. We also have on our website, a COVID-19 client resource page where you can tap into various resources. We're doing a number of webinars, as you're well aware, on Facebook. We post them as well on the website. And I do a daily check-in at least twice a week now, where I check in and talk for 3 to 5 minutes about things that I think are important and that hopefully can make a difference in your lives. And I know, Ashley, we have a number of webinars coming up. You want to mention those?
I do. Thanks, Vincent. Our next Facebook Live webinar is on September 1st. That's just 2 weeks away. We'll have 2 of our partners, attorney Maria Elena Puma and Eric Einhart, discussing some of the common probate mistakes and how you can avoid them. And if you all want to sign up right now, I am chatting everyone the link to register as we speak. All right, as Vincent talked about in the beginning, today's program is part of a webinar series. So our next estate tax planning webinar is September the 15th. Vincent will be back discussing federal estate tax planning. There's no need to sign up. You're already registered for the series, so just mark it on your calendar and we'll see you then. And we will round out the series on October 20th with estate tax planning for married couples. And finally, I would like to mention for anyone on the session who either is a healthcare professional or maybe you know of one, we are hosting the 29th Annual Elder Law Conference for Healthcare Professionals. This year is a virtual event. It is worth 3 CEU credits, and it is taking place September 16th. So let us know if you need any more information or have questions about our upcoming programs. And Vincent, that's all I have if you want to wrap us up.
All right, thank you, Ashley. We're very busy, I see. And that's really good for us and for all of those who take advantage of our webinars. So please be safe, wear a mask, wash your hands, do the social distancing. It's really important. Here in New York, it's really making a significant difference. And keep in touch with us. Take advantage of our webinars. And lastly, if you want to get into actively planning your estate out to minimize estate taxes, call us up. Ashley will be the point person who will speak to you, and then we can make arrangements from there. Have a great day.
Thanks. Bye, everyone.